Good morning, everyone. Welcome to the Board of Zoning Appeals for this Monday, August 2nd. Sorry, August 12th. I'm still recovering from the power outage. Just really still a little sleep deprived. Okay, so we're hybrid today. So we'll begin with the reading of the preamble.
Thank you. Good morning, my name is Liz Kukla. I'm the Secretary of the Board of Zoning Appeal. I'm going to read the preamble for you this morning. This is August 12th, 2024. In compliance with notification requirements of the city's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conduct its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that calling users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube. We provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received email from those who provided written comment on a particular matter. Back to you, Madam Chair.
All right, do you want to call the roll, please?
Sure. Ms. Roca? Present. Ms. Holzer?
Present.
Ms. Bay?
I'm here.
And Madam Chair, Ms. Wilson will be absent this morning.
Correct.
So this morning we have 3 members. To the appellants, we'd like to state that while we have a quorum of 3 members, in order for a motion to pass, the vote must be unanimous. If the vote is not unanimous, the decision remains unchanged and the variance is denied. Therefore, at this time, the appellant may request a postponement to a date in future when we would likely have 5 members.
Right. Okay, so we are awaiting 5th member. So in the very near future, we will have a full board of 5 members. But we do, as Ms. Kukla noted, today we have 1 absence, so we are at 3 today. So do we have anyone in the room who wishes to postpone their case? Okay. Do we have anyone online that wishes to postpone their case? All right. Hearing none, we'll move forward.
Thank you, Madam Chair. There are no withdrawals this morning. However, we have received a request from License and Assessments. And I believe that Ms. Fulton's here to deliver that request.
Okay, for calendar 24-111.
That's correct. First one on the agenda.
Okay, let's go ahead and read that in and then we'll go to Ms. Fulton.
Oh, sorry.
It's okay.
So,
It is just, it's gonna take us a while to recover.
yeah, I think so. Our first case is calendar number 24-111. This is the administrative appeal. So it's the appeal of, and I apologize if I butcher any names, Paradis LLC from the decision of the Commissioner of Assessments and Licenses to deny application PBPN 23-00108 at 620 Frankfurt Avenue. Paradis LLC appeals under the authority of section 76-6B of the Charter of the City of Cleveland and section 329.02T from the decision of the Commissioner of Assessments and Licenses to deny entertainment venue license application PBEN 23-00108 at 620 Frankfurt Avenue. With that, I will hand it over to Mr. Rubio.
Thank you. I'm swearing in all who are present for this case. Do we have anyone in the room today? You want to come up?
Miranda Talton.
All right, we'll start with you, Ms. Talton. Do you swear or affirm the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply with I do, and state your name.
I do. LaRonda Talton Morris, Commissioner of Assessments and Licenses. Assistant Commissioner, I do apologize, of Assessments and Licenses, 601 Lakeside Avenue, room 122.
Thank
And
you.
with her, Madam Chair, Vishnu Ganglani, from the Law Department with Ms. Talton at 601 Lakeside Avenue.
I'm sorry. Okay, we didn't hear your name, sir.
Vishnu Ganglani, I apologize that the audio is not very good. We can't hear you that well either. But yes, it's Vishnu Ganglani with the Law Department
Can you spell
of
the
the city
last,
of Cleveland.
thank you, can you just spell the last name, sir?
Yes, Ganglani.
Thank you.
Thank you.
Mr. Bay, do we want to move this microphone maybe closer?
Yeah.
Maybe more central in the table or something?
Let's see how much.
Yeah, I don't know which word.
We'll try
That
to
much.
speak louder.
All right. Well,
Okay.
okay,
All
great.
right, and now to you, sir. Do you swear or affirm the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, state I do, state your name and address.
My name is Willis Tavon. That's 620 Frankfurt. So,
Can you spell your last name, please?
TA, B as in Bravo, R as in Nick.
Thank you. Back to you, Madam Chair. Is anybody else on the call?
Yes, I'm here. My name is Jeanette Sharara. And I'm the new owner at 620 Frankfurt Avenue.
And ma'am, can you please reply with you do and your address?
I do, and it's 620 Frankfurt Avenue.
Thank you.
And can you spell the last name, please?
Yes, CHARARA.
Mr. Bay, I saw Kim Scott pop in. Is she for this case?
No, I believe she's for the next case.
Okay, super. All right. I just want to remind everyone, as we're swearing you in, and before you make any statement, our court reporter is working remotely today. So what you'll need to do is be sure that you're spelling your first name and your last name for the benefit of the court reporter. And before you make any statement, be sure to state your name. Okay? All right. We'll go to legal standard.
Madam Chair, members of the board, appellant is appealing an administrative decision of the Commissioner of Assessments and Licenses. The standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. If the appellant fails to meet this burden, the administrative decision must be affirmed.
Great, thank you so much. Right. Excuse me. Ms. Talton, I'm gonna go to you first because you had something that you wanted to share with us.
Good morning. I'm going to turn it over to Mr. Ganglani for the explanation.
Great, thank you.
Good morning, honorable board. Thank you for mentioning, showing the exhibits. I met with Ms. Kukla and she kindly included that in the presentation today. This is a license that was rejected for a dance hall. And just to give you the premise, the Division of Assessments and Licenses, it's a conduit for various recommendations from building and housing, health and safety, and public safety on the recommendations of which city departments the license application was rejected. So we receive, as you already know, honorable board, the division receives recommendations from the various departments, and then based on what is presented to them, either approve or reject the application. Supporting documents were provided to the secretary of this board accordingly. However, we found a procedural issue that still lingers. We're contesting standing of the appellant on the basis of the exhibits that is now on your screen. which show that the alleged aggrieved party is not presently associated with the property. So if you go back to Exhibit A, please, it shows you Paradise LLC at 620 Frankfurt. And if you go on further to the next exhibit, please, B, you'll see, if we go back one more, sorry, guys. Yes, there you go. Exhibit B shows a general warranty deed showing 620 Frankfurt Avenue. It's under ownership of Frankfurt and Sixth LLC and not Paradise LLC, which was the applicant. So that's one inconsistency there. And another issue, if we go on to our Exhibit C, please, it's aggrieved party is a limited liability company. If we keep going, one more, please. And one more. There you go, and just one more, please. So here you'll see that the Paradise LLC does not have active status as shown on the Ohio Secretary of State's websites and records. It does not have active status. This is an exhibit showing that the company was canceled. And then subsequently right now it's showing it has a held status. So it's not active. As you're already aware, board members, limited liability companies are artificial entities and creatures of statute having existence separate from their members and managers. Our state's Limited Liability Company Act is codified under Revised Code Section 170604 and defines an LLC as a separate legal entity with perpetual duration that can sue and be sued. What we're trying to get at over here is who we're providing relief to. Paradise seems to not have active status. This was the entity that applied for the license. As you can see, 620 Frankfurt Avenue now has a different LLC on there. So we're requesting that you uphold the commissioner's decision as correctly decided and dismiss this appeal. And I'm here for further questions.
Super, thank you, sir. All right.
Thank you.
Oh. Ms. Halton, did you have anything else?
No, ma'am.
Okay, great. All right, Mr. Gibran, how are you associated with this business?
So Paradise LLC, I purchased the building back in 2019. Had the company since 2019. And April of 2023, I sold the business to Jeanette Schwarr.
I'm sorry, we can't hear Mr. Tabron. He's very muffled.
We're having microphone issues.
Okay.
In April of 2023, I sold the business to Jeanette Schwarr. The only reason why I even put my name on the application is because it goes hand in hand with the liquor license. Other than that, I would have put it in Jeanette's name, but she has no control over the liquor license as of right now. This is holding us up to transfer the liquor license, so I couldn't put her down as the owner of the liquor license because they haven't transferred it to her name as of yet. So that's the only reason why I put down Paradise. Businesses, so Jeanette is a new owner, and we're just trying to get everything resolved so I can move forward. So it wasn't like I could put her on file. As you can see that Paradise is no longer affiliated with 625.
Right. Okay.
So I apologize to the courts. I could have put her name down, but I can't associate or affiliate her with the liquor license because it's been transferred to her name. So when they ask, well, who's in charge of the liquor license, I still have control of the liquor license.
Right.
Because they have to transfer it over to her. So that's the technical way that my lawyer told me to do it. I have to fill that out.
Right.
Everything else is in Jeanette's.
And can I add something also, please? This is Jeanette Sharara.
Quickly, go ahead.
So the liquor, I plan to open by the end of the month, and then the liquor license should transfer soon after, within a couple weeks. And once that transfers, then I'm allowed to apply for the new business application. And that's when Will will have nothing, his name won't have to be on my business and he'll have nothing to do with it.
Okay, well, so here's the situation, okay? Your LLC has been canceled. The city attorney just made statement that it has been canceled, and they're looking for this case to be dismissed. So we cannot approve this with your business being canceled.
Okay, so do you want me to?
You need to reapply with the new owner. Is that correct, Ms. Kukla?
I would defer to, Ms. Talton or Attorney Ronnie, to see if
Okay,
if we have that correct.
all right, to Ms. Talton, the attorney, can you verify the statement I just made in the course of action necessary for the appellant?
Yes.
Oh,
Go on,
ahead.
Miranda.
Go ahead.
Okay. Yes, thank you, honorable board members. We do concur. The license is made out to an entity or a person. In this situation, we don't have that. So we defer to the board's decision. At this point, a license can be granted to an LLC that does not have active status or is canceled.
Great, thank you.
We concur with your decision and defer to you.
Madam
Okay.
Chair, I have just a question.
Yes, go ahead,
Two
Ms.
questions.
Rocco.
First for Ms. Sharara, is it your testimony that the business is closed right now, and how long has it been closed?
It's been closed for a really long time. I've been remodeling, you guys can drive by and see, I've been remodeling it for months, and we were just hoping to get this license approved, and then once the liquor license gets into my name, it'll transfer, that's when I'll apply for the new business license and have it transferred into my name.
Okay, so Mr.
Taylor.
Avon wouldn't be the one to reapply, it would be her. who would be
Correct.
the one to reapply.
Right,
Yeah, so you won't have anything to do with this.
Perfect, that's.
Lucky you.
and you are not gonna be party to the new LLC?
No.
Okay, all right. Anything else? No? Okay,
And through the chair to the board members, if I may, this is Attorney Ganglani. Just to bring your attention back to Exhibit C, that there is a Frankfurt and Sixth LLC, which is now associated with a property. So just to put that out there as well, that it appears that the new applicant for the license will not be Paradise. If Ms. through the chair to Ms. Charara, if you would confirm that the applicant, the new application will be made by Frankfurt and Sixth LLC.
Yes, it'll be made by Frankfurt and Sixth LLC, which is in my name, and will have nothing to do with my business.
Thank you.
okay, anything, Ms. Holzer? Okay. So we need a motion to.
So we're dismissing and allowing the new business to reapply in the future.
Correct.
Madam Chair, based on the testimony we've heard today, I move that we dismiss calendar number 24-111.
Thank you. Can I have a second?
Board Member Holzer, second.
Ms. Holzer for the second, call a roll, please.
Ms. Holzer?
Yes.
Ms. Rocco?
Yes.
Yes,
Number 24-111 is dismissed. This will be ratified next Monday, and then we'll send the appellant as well as the city a letter.
okay, so you clear on what has to happen? Okay.
So when can I apply for my new license? Do I have to wait for my liquor license to transfer, or can I just apply for it today?
We're gonna have you get in touch with Ms. Talton about that.
Okay,
She's gonna be your point person at this point.
okay,
Okay,
okay, thank you.
super, thanks. Okay, thank you so much.
Thank you.
Thank you.
Thank you. Have a great day.
Great.
All right. We have Councilperson Gray who's joined us, so we'll take, which as it turns out is the next case anyway. So we'll go on to calendar number 24-115.
Our next case is calendar number 24-115. This is at 13708 Arden Avenue. Tana Kowalski, owner, proposes to erect a one-story frame living space addition to an existing single-family residence in an A11 family residential district. The owner appeals for relief from strict application of the two codified ordinances as stated in the agenda and the public record, of which there is one, with a note that Land Use Commission approval is required before issuance of a permit. With that, hand it over to you.
Thank you, Ms. Holzer. I'm swearing in all who are present for this case. Councilwoman Gray, do you swear or affirm that the testimony you're about to give is the whole truth, and nothing but the truth? Please raise your hand, reply with I do, and state your name and address.
I do, Gray, so
And is there anyone else in the room?
Can you hear me? I'm Brandon Krastowski.
Just a moment,
Just a
please.
moment, sir.
We're doing it in the room first, and then we'll get to online.
Thank you.
I'm swearing in all on the call. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply with I do, and state your name and address. Sir, I'll go with you first. If you could spell your last name as well when you reply. Mr. Krotowski.
Oh, I'm sorry. I thought are you online now?
Yes, I'm online now. To you.
Okay, gotcha. Yeah, CHROSTOWSKI.
And do you swear or affirm? Say I
Yes.
do.
I do.
And what's your address, sir?
13708R Dune.
Thank you. And then we'll move to the
Hi,
person.
this is, sorry, Katana Krastowski as well. I don't know how to raise my hand on this, but I also live at 13708 Ardoon, and I swear as well.
Okay, thank you.
What was the gentleman's first name, Mr.
Chris.
Brandon, Brandon.
Wrong name.
Brandon? Okay, great, thank you. All right.
All right, the next person with their hand up looks like Miss Chappelle. Do you swear or affirm that the testimony you're about to give is the truth and the whole truth? Please raise your hand, state I do, state your name and address.
I do. Tamara Chappelle, 13715 Cormier Avenue.
Thank you. The next person with their hand up, Mr. or Miss Chesterfield. Do you swear or affirm? Please state your name, spell your last name, and state your address.
Jessel. H-E.
Thank you. Is there anyone else on the call who would like to speak today? Hearing none, back to you, Madam Chair.
It's always fun. Okay, history of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that a permit was issued in 1926 to erect a dwelling in a garage. There are no variances on file and nothing of note in the more recent history. Thank you.
Super. We have legal standard, please.
Madam Chair, members of the board, appellant is requesting an area variance from the minimum required interior side yard requirements of the zoning code. To obtain the area variance, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting variance will not be contrary to the purpose and intent of the zoning.
Super, thank you. Mr. Bay, do we have any ruling from landmarks on this at this point?
I'm not certain. I know that after discussing this case with the neighborhood planner, Kim Scott, she mentioned that landmarks didn't have an issue with the addition proposed. I believe there's some more comments about the type of window that was going on the face of the building fronting Ardoon Avenue. Basically, the request from landmarks was that they keep the windows consistent.
And that was it. Just consistent windows.
Yes, correct.
Okay. All right, super. Which one of you are going to speak? Katana, are you going to be the spokesperson or Brandon?
I don't mind being the spokesperson, and if there's anything I missed, my wife will fill in the blanks.
Okay, go ahead and tell us what you'd like to do with your property as it relates to the variance that you're seeking today.
Thank you, everyone, for being on the call. So the goal is, we have 4 children, all athletes, and we need a bit more space. So what we're trying to construct is a addition to our house that extends, and my wife can tell exactly, 8 feet from our existing house on the west side of the house. It is going to be built for a locker room, storage for all the equipment, and keeping things organized. It will not be a place that someone dwells. It's not like separate plumbing is going to be installed. It is simply just an extra space. We plan on using the same sort of siding to mimic what you have, and use the windows that we'll be removing on the side to face the, Ardoon Avenue to the north. So it's an extension that will be similar to what the house looks like now and resembles. It is 3 feet, a little over 3 feet from the property line, which is not code, but it's 13 feet, over 13 feet from the our neighbor to the west. So that's why we're requesting the variance. It doesn't meet the minimum standard, and that's why we're here today.
So this essentially is going to be more like a mudroom kind of situation with the lockers and the storage for the athletic equipment?
Yeah, that's the best way to describe it. A very simple bump out of the house to keep all the sports equipment contained. And, with the 4 kids, this just makes it easiest.
And I believe you said that the window that is going to be removed from the west elevation when you do the extension is going to be repurposed for the front elevation. Is that correct?
Exactly.
Okay. So that would fulfill the window consistency, correct, Mr. Rand?
Correct.
Are those the historic windows, sir?
They're original with the house.
Thank you.
That would be yes. Okay. All right. All right. Does Mrs. Kurtowski have anything to add?
I do. I just wanted to add 2 things. First, the bump out is actually only 7 feet. It's under 8 feet. The interior will be just over 6 feet, just to allow room to walk with the lockers. And then to address, the gentleman was discussing earlier, Landmark's concern about the one window in the front. When I had the original drawing done, I had the window sort of centered the height of the new bump out, and they wanted it level with the other front window of our house. So that was the concern about the window. So I resubmitted a new drawing where it was level. So that it was a very minor change. I already submitted the new drawing to Landmarks, and I submitted it to Building and Housing, and you can see it in I think the first drawing that you displayed here, that the window is now, the drawing makes it level. The window on the far right of the bump out is level with that small window to the right of our front door. That was what they changed.
All right, so they just wanted all the sills at the same elevation. I see that.
Yeah,
Correct.
so I had the drawing changed, and that's the plan now.
And you said the new drawings have been submitted.
To Landmark, I sent it to them. I don't know that they care sort of after the fact of the meeting. They just said, please make this change, but I submitted it to Building and Housing as well.
Great, super, thank you. I'm assuming you want to go last. Or, yeah, okay. Okay, super. All right, we'll go to Ms. Chappelle.
Thank you. Good morning.
Good morning.
I live around the corner. My backyard is adjacent to Brandon's backyard. And I spoke with his neighbors when I first received the letter. And this isn't the first time somebody on Ardoon wanted to do something that had to come before you. And they wanted to put a bathroom over a garage. Now with this addition is fabulous, but it could also be a wonderful shed on the side of the garage. There's enough room to put an even larger shed on the side of the garage. With this 3-foot encroachment, it gives you enough room in the house next door, about as much room as you have in a sedan, which is way too close. Our houses, the houses on Cormier have that side porch. The houses on Ardoon don't. So that just puts it way too close. And the fact that the neighbors weren't spoken to about something happening, I find a little disturbing, especially since the woman next door who will be immediately affected by it is going into a nursing home, and her family is trying to put things together to put the house up for sale. I think that having a structure in their living room will deter from the sale of the house. But putting a nice shed in the backyard won't be in the way of anybody. And it could be larger. I have an athletic son and I had a lot of equipment at my house, and it's only good for a year. If they do it right, they're done with it. Away from the house, you don't have to smell it. So I would consider not allowing this to be built. It's not enough room. It's an encroachment of the neighbor, and there's enough room next to the garage to put it next to the garage. Thank you.
Super, thank you. All right, we'll go to Ms. Chesterfield. Good morning.
I did speak to. I did to my feet over.
I can't hear anything.
Okay. Ms. Chesterfield, your connection is a little bit garbled. Try again.
No.
Go ahead and start. Yeah. See if you can fix.
Here's the bad connection.
Yeah, she's got a bad connection. You're on your phone. Yeah, we've got a bad connection. We do have your letter. We do have your letter that you sent. Okay, all right. Mr. Bay, while we're waiting for Ms. Chesterfield to get situated, do we have any statement from Kim Scott?
She is still online. Kim Scott, would you like to unmute and chime in?
Good morning. I don't really have anything different than what Mr. Bay added, just that I did speak with the Landmark staff, and it was confirmed that this had gone before the Landmarks Commission or staff and was approved. So that's all I have.
Okay,
Thank
so
you.
Landmarks did approve with the window change that was made.
Correct.
Okay, super.
Yep.
Okay, Ms. Chesterfield, are you with us?
Coming.
Okay. You want to make a statement at this point, or you want?
At this point, yes, at this point, I'm also. And I know just to the attention, they were they increased the section only because he was the only one on he was the only one at the meeting and not the other partner. And now since this came to my ability to say, you know, so can't go on this one already approved.
I'm sorry for interrupting. I can't hear what the person in your room is saying.
Okay, I apologize. I'm Councilwoman Deborah Gray, and I'm on the Landmark Commission as well. And when this was approved months ago, Mr. Kasaki was the only one there in the meeting. There was no one else there to contest what you brought to the Landmark Commission. So at that time, we all approved it. So since I'm here, I cannot go back on what I already approved. when the landmark commission board.
Right.
So. I'm just going.
There was no opposition in Landmarks, and Landmarks has approved it.
And we haven't been to it, so I'm here today just to clarify.
Right, thank you.
And for clarification, it was approved on January 11th of this year.
Okay. Great, super.
So.
Okay,
I'm gonna
Miss-
excuse myself.
yes, absolutely. Yeah, that's why I wanted to see if you wanted to make a statement, because I know usually you're trying to juggle two things. So good to see you. Ms. Chesterfield, are you with us now?
Code or
Excuse me, Madam Chair. Yes, Ms., through the chair, I just sent you the meeting ID, through the chat. Let us know if you can see that, as I attempt to call in.
But she said she's on the phone, so I don't even know if she's gonna be able to access the chat.
Okay. Mr. Bailey, we have to set back from the property line for the neighboring house, by chance.
Not for the neighboring house, I don't have that information. You could ask Elizabeth Kukla, the secretary, do you know if that information was submitted?
I do believe we are. I believe it's 13 feet, maybe the appellant, I found it. It's 13 feet, 3 inches.
Okay, so the house to the west, which will, which abuts the property, the side of the property where the extension is going to be made, the distance is 13 feet 3, correct? Yes.
Correct.
Okay. Plus the distance of 3'3", which is the proposed setback. You want to see this, Ms. Rogan?
Madam Chair, it would just be 13 feet, 3 inches over.
Oh, the 13'3", okay, so they're 10 off, plus the 13'3".
I believe,
So there are 3 off the property line, right?
3'3",
3 off the property line and 13 from the neighbor.
right. So the neighbor's setback 10.
Right.
so they're measuring from the addition to the house? Or
Right.
is it from the house, existing house to the house? I think it's from the
The
addition.
13.3 is from the addition to the next.
To the next house. Okay. All right, how are we doing with Ms. Chesterfield?
coming.
Looks like she's attempting to call in.
Okay, all right. We do have her correspondence in hand. Let's go see, do you have any questions? Let's go to questions.
No, I mean, my questions would be for her, so.
Ms.
based on
Chesterfield,
What she put in her letter.
okay. You have anything?
It sounded like she was beginning to say
Okay.
something different.
All right. All right, we've covered everything we can cover until we have Ms. Chesterfield. Yes? Okay.
Is it a spec as well?
It's not accurate.
No.
That's the. Yeah.
The appellant submitted that.
I think she can speak now.
Ms. Chesterfield?
Hello, can you hear me?
Yes, go
Yep.
ahead.
Oh, yeah.
Go ahead, Ms. Chesterfield.
Hello?
We can hear
Hello,
you.
we can hear you.
I can't hear you. Can you hear me?
Yes.
Yes, we can hear you.
Can you chat to her that
Yes.
you can hear? She can go ahead and make a statement. Go ahead with your statement, ma'am. Hopefully she knows how to read the chat.
She might have us on mute.
Can you hear me?
Yes.
Yes, we can all hear you.
Okay, because I can't hear you. So
Yes, we can hear you still. Maybe someone can call Jess and tell her we can hear her or text her. Katana, do you have a number?
Sir, we're in the process
as long as you
of
can hear me, I'll just go ahead.
communicating with her
If
through
somebody can
chat.
put something in the chat saying that they can hear me, then I'll just go ahead and say what I have to say. I have a couple of problems. I think Tamara basically said it the best, but I'm going to just state a couple of things that I feel are bothering me. For one thing, I think the extension is too close to my property. The plan is to allow the extension to be built 7 feet over the interior side yard requirement of 10 feet. This is no small variance. An extension of 7 feet close to my home is too close. My house is wood. An extension that close is a fire hazard for both my and Katana's and Brandon's homes. If there is a fire in the Kotowski's home, it is likely to spread to mine and vice versa due to the closeness of the extension. The extension will make it difficult for maintenance on the side of my home that abuts the planned extension. The space on the left side of my property, which abuts the proposed extension, has several large pine trees. I sent the communication with the pictures. These trees serve as a natural cooling system during the hot weather, as I don't have central air. Pouring concrete for that foundation for the proposed extension would require that this concrete would have to go underneath the drip line of the trees. That construction will, of course, require disruption and destruction of my trees' root system. And destruction of the root system will eventually lead to the death of those trees. Once it appears that the trees are dying due to the destruction of their roots, I will be required to bear the cost to have the trees cut down or for the safety of my home as well as the Krastowskis. And I will lose the use of the trees to cool my home. The proposed addition, as told to me by Katana, is for storage of sports equipment. First, although the Krastowskis have several children, I believe 4, I question just what amount of athletic equipment there is requiring a space that is 7 feet extended from their house. And the 10 feet tall, as it appears in the design plans, stands across the majority of the side of their home, which I'm guessing from the plans is going to be about 11 feet. The Krastowskis have a large backyard. I also sent an attachment of the fence that shows the yard, the space of which they rarely use. Their children play in the front yard with their parents daily. This leaves the backyard open for an extension of their property that would not change my view from my bedroom window. I do not want to look out of my window and see a looming addition off my neighbor's home. The extension can be built off of the back of their home. There is a patio that is next to the back of the house. The area could be the foundation of their addition. Again, instead of threatening the health of my trees and changing the aesthetics of my view from my home. I find it difficult to believe that anyone would want the traffic through the living room and dining room to get to an equipment storage room. Building it off the side of the house when there are far less intrusive options seem to me to be just so that they can continue to complete and enjoy their home, but it's not taking into consideration the neighbors. There are ready-made storage sheds, even heated ones. As someone spoke previously, basically you could build it off of the garage. There's plenty of space to build it off of the garage. And finally, I think I noted about the board's ordinance, which it gives the power to the board to grant a variance to the applicant if the board's denial of the variance would cause practical difficulty or unnecessary hardship. Section B uses the conjunctive and, which indicates that all three paragraphs must apply in order to grant the variance. I argue that denial of the variance at the very least will not deprive the owner of a substantial property right, nor present practical difficulty or cause unnecessary hardship. And for those foregoing reasons, I object to the granting of the variance. And perhaps there is something else that the Krastowskis can do in terms of getting this shed. Basically, I think that the best option would be to build it off of their garage. Thank you.
Thank you, Ms. Chesterfield. Okay, Mr. Kurkowski, I'll give you an opportunity to reply back to the statements of opposition.
Check your volume. I did check my volume. There's right there. I don't.
Ladies?
I'll wait till someone
Moving
stops
on.
talking there. Okay,
Go ahead,
no, thank you very much for the statement. And we appreciate the, the candidness with this. Well, a couple things I'd say is, one, we did consider, and it's a great idea to put the addition on the rear of the house. Again, digging the depth that concrete has to be dug, we found some issues with our utilities and lines. And we thought that would be more of a disruption and to be honest with you, not as cost effective. Two, we have charted the line on which we'd have to dig on the side of the house, and we did not encounter any roots of that size or significant to alter the pines that would be there. Three, I'd say the biggest fire hazard we have is our neighbor to the west, Miss Jess. Her house isn't maintained, and so there's a lot of debris, old pine needles, cones, dead branches, debris that would be more combustible than an addition that's within our home that's got a fire alarm, etc. That would be my only rebuttal to that. The aesthetic of it, I can't say much to. I completely understand if it's an eyesore, but no less than an eyesore of an unmaintained ground that we inhabit next door. So I just want to make sure we're clear on the the reasons why and the truth of the matter, because I think we're actually right now looking at something less attractive next door from our sight line. It also is more of a fire hazard because of all the debris that's not maintained. But other than that, I understand what you're saying. We don't look at this as a shed. We look at it as part of our home. We have 4 kids, 2 of which are active in hockey, baseball, another with figure skating, soccer, and the 4th one obviously will follow in those footsteps. That is in addition to the equipment that I have for our sporting, coaching, and my wife has for her riding. So all in all, the space is much too small than we would hope. But we thought we'd make a compromise and make it this length. The last thing I said, there was no objections to this when communicating. In January it was approved. We haven't heard anything other than that since. But it's up to you, ultimately the board. You have everyone's points of interest, and we just thank you for your consideration.
Okay, thank you. Right, and we've had testimony from the councilwoman and from city planning that you were approved through landmarks, and there were no objections when you were approved in the January landmarks meeting. I'm interested to know, you mentioned you did some testing, the extent of the testing. Did you do bore samples? What exactly did you do? with the soil to, make sure that you were not gonna be, hitting any of the tree roots or impeding, in the root system when you do your excavation and construction.
Yeah, we actually did a small excavation around the same perimeter in which we thought we would, lay concrete. And the interference wasn't such that we saw any roots that would, like, we didn't have to chop through any roots, so we didn't find well, I mean, we're not arborists, I'm not going to pretend to be, but from a plain sight, we just didn't see the root stream. If anything, we saw like a root coming from our yard west from a tree that was chopped down many, many years ago, so that looked kind of crumbled. But other than that, it wasn't a structure in which we thought was difficult to get through.
And to what depth did you go?
We went down 3 or 4 feet, well, the code, whatever code is, I think it's 36 inches.
Okay,
It's below the line, so we went down the full depth in which we understand to go through.
all right, so your construction is gonna be on a footer with a slab, is that it?
Correct. The footer would reach the perimeter, which we dug, and then in the middle would just be dirt with limestone and then a slab on top of that, in which we would build the structure.
Okay, all right, so they're just going down for a footer.
Madam Chair, I have a
Yes,
question.
go ahead, Ms. Ruka.
I know Ms. Chesterfield can't hear us, but in her letter objecting to the variance, she noted that it would be difficult for her, in her testimony, to maintain her property based on the proximity of this addition to her house. So I would just like to give the appellants an opportunity to provide statement as to whether this addition will in fact impede Ms. Chesterfield's ability to maintain the side of her house.
It's not being maintained currently.
But that's not the question I asked her. I asked, will it impede her ability to maintain the side of her house? Not, is it being maintained?
Oh, I'm sorry. No. I mean, we're still over 3 feet from a fence line. I just had to understand what actually it would be trying to. I don't know what it would impede. It's 3 feet, over 3 feet from a fence line. So the answer would be no, unless there's a very long, 20-foot hole that has to be. I don't know. I don't know what actually would.
For example, sir, if she were to have to replace the siding of her house or paint her house, would she have to come onto your property to do that, or could she do all those things on her own property with this addition?
Oh, yeah. I mean, I'm sorry. I don't know if this was even stated, which is kind of silly, but there is a fence in between our properties, and no, it would not impede her painting her house from the fence line, which is, I believe, 10 or 9 feet from from the fence or house. It was an additional 3 feet 3 inches. So no, it would not impede it in no way, shape, or form.
And is that fence your fence?
Correct. Well, when we moved, I don't know whose fence it is, to be honest. When we moved into the house 10 years ago, there was a fence in between our yards. And this fence is, 9 or 10 feet from her house, and this fence is now, 9 or 10 or 10 feet from our house.
It is our fence.
It is okay. It is our fence. So it would then be the extension, 3 foot 3 inches, our fence, and then another 10 feet for her house.
Okay, thank you.
May I make a comment about the fence, please?
We're doing questions right now, ma'am. Just a moment. Okay. All right, you can make a quick comment, Ms. Chesterfield.
The fence that, I know I'm echoing, I'm sorry. The fence that's being referred to, there's some dispute as to who the fence belonged to originally. The fence line is the property line. Brandon and Katana tore down the original fence without letting me know. And all I knew was that there were workers outside. And the fence that they built, even though it's very, very nice, is 4 inches over on my property line. If they were to go out and look at the continuation of the wood fence that they did not tear down, that is our property line. And the new fence is over on my property. But that's not the issue here. This is basically about whether or not there's something else that can be done other than basically destroying what I consider aesthetics. And I know that Brandon's going to say, no, there's not going to be a problem to the trees. I just doubt that that's the case. And if they can build it someplace else, why not build it someplace else? I don't understand why it can't be built in their basement. I don't understand why it can't be built off of their garage, why it can't be built off of the back of their house.
Ms. Chesterfield, we
That's
are
what
here
I
to,
would like an answer to.
we are here to adjudicate the side yard setback. The plans were submitted and have been approved by Landmarks back in January.
The landmarks only approves the design.
Right, the Landmarks
Sort of
approved the
design.
right.
So we're here to either approve or deny the actual variance for the setback.
For the setback. So the aesthetics of the building are not, that's not what's before us. I see Ms. Scott has her hand up.
Yes, thank you.
Oh, sorry.
I just want to state that although Landmarks approved the design, they did not give consideration about setbacks. I don't think. I mean, I wasn't there. I didn't listen to it, didn't participate in that meeting, but I don't know whether that was a consideration. So I just wanted to state that.
Thank you,
Okay,
Ms. Scott.
Thank you.
I would assume that it was not a consideration because that's our job.
right. Okay,
Madam Chair,
yes, ma'am.
did the appellant explain the reason why they did not choose to extend?
Yes. Right, they have utility issues. Okay, Mr. Kurkowski, sorry, I'm mispronouncing your name, I apologize. Have you
That's okay.
have you had your lot professionally surveyed and staked?
I'm sorry, the property professionally surveyed?
Right, so that the lot
Yeah,
line between you and your neighbor, was it professionally surveyed and staked?
I believe we still retain the survey from its original purchase, and that was professionally done, correct?
But, so it was never recently staked? So that the lot line was visible to you and your neighbor?
Yeah, the lot line is visible to myself, and I believe the neighbor. I don't know if she looked at it or not, but yes, it has been. And we're just following essentially the same lot line as that was issued when the property was built.
Okay,
Like I said, I don't think that it shifts or changes, is what I mean to say.
no, it doesn't shift or change, but typically when you're gonna do this kind of project, you would go
Yeah.
ahead and have it professionally staked, so that the stakes would serve as a visual indicator to both parties, so that they would know where the lot line was, so it was clear. Okay, Ms. Roca, you have a question?
So Ms. Wilson's not here today, so I'll take her normal question, and ask that
Go
of the
ahead.
appellant. Sir, could you please state what difficulty you will face if this variance isn't granted today?
I'm sorry, if there was a question, I didn't hear it.
Sure, yes. Can you hear me now?
Yes, ma'am.
Okay, great. If you could just state for the board what difficulty you will face if your variance isn't granted today.
What difficulty will face?
Will you face?
I mean, like financial or like maybe a product or something that got delayed, and is that what you're saying? Like a construction issue? Like
Sir, what will be your hardship? What challenges will you face, whether it be economic or whatever the challenges are? If we deny your variance today, how will that affect you?
If you deny it or grant it?
Deny it.
Oh, if you deny it, financial hardship, I mean, we'll make do with what we have, I think, as we always have in life, right? I think the hardship it would really incur is just keeping all of our stuff in a space that we have enough room for, which is not a hardship by any stretch. The only financial hardship would be obviously is well, if you don't grant it and we don't build it, so there's no cost of building it. Yeah, there's really nothing I can think of that it would hurt us more financially.
And your wife has her hand up, so we'll let her respond as well.
I actually had a few points to respond to, if that's all right. To answer your immediate question, hardship, so Brandon addressed, I'm not sure why Tamara was commenting about, our kids and we should be getting rid of equipment every year. We have 3 children. We pass equipment down, the oldest being 9, the youngest being 1. So there is a large volume of sports equipment because I store and organize everything by age, by size, so that we don't have to rebuy equipment, which would be a waste of money. And so that I know, like, for instance, with helmets, I'm not going to buy a used helmet. I want to purchase it myself and know if there have been prior impacts, for instance, to a hockey helmet. So it's simply virtue. We now have, only so much space in our house, and our one room is just being overrun by sports equipment. We don't want to put a shed in the backyard or add on to the garage because there wouldn't be a climate control. And so, and there's, spiders, things like that. And I don't want this equipment molding. If it molds, then our children can't use it. So to me, it does create a hardship by just having the volume of sports equipment we have in our house and, nowhere to put it. We have 4 bedrooms with 4 children. So we already have 2 children sharing a room. So it's not like we have, an abundance of space left in the house for this. To address a couple of other points, she was talking about her pine trees and, needles possibly falling on our bump out. They already fall on our existing roof, which we keep maintained because the branches on our pine trees aren't cut back. So they're already a nuisance to us. So we would just continue dealing with it in the same way by removing the needles from the bump out. To her point about visual being unaesthetically pleasing, Landmarks did review the setback like from the front yard. And we have the bump out does not come to the front plane of our house. It's set back from there. So when you're driving by from the street, it's not like you'll see this bump out along the front plane. It's a few feet back from the front of the house. So it's not, a visually not appealing. They covered a lot of things to make sure that it would be visually appealing. And then our next door neighbor on the first floor, I'm not even sure what her bump out is on that side of the house, but her blinds are always closed. And the second floor has the block windows. So it's not like it would be visually unappealing looking out the windows because they never have those windows open anyways. As far as the fire hazard, in the last 10 years, Miss Chesterfield's house is the only house that caught on fire between our houses. She had a major fire. Her trees would have potentially been the fire hazard bridging between our homes, and they were not. The fire didn't spread our house. And just to note, we are not terrible neighbors. Brandon did run in her burning house because she didn't know where her son was to look for her son while she was waiting outside before the fire department got there because they hadn't run in yet. So I think we've been more than good neighbors. We did not, I did talk to Tamara or to Jess before this meeting. And when I talked to her, I addressed everything that we were going to be doing in the bump out, what it was for, we weren't building this sunroom or to be like sitting, staring out windows, looking at her house or playing loud music. And then if anything, we currently have windows on that side of the house. We would no longer have windows facing her house. So it's not like we'd be staring at her property. And then back again, she was talking about the fence that we replaced. So I did it within the city of Cleveland requirements. We only replaced half at a time. And the reason we had to replace it was because after the fire, she had like a herd of deer living in her backyard. And they kept jumping over the fence and knocking it down. And they were bringing ticks into our yard. And so we had to replace the fence so they wouldn't keep knocking it down. The nice or pretty side of the fence faces her property. And I think anyone in construction knows the not pretty side of the fence faces the owner's property. And we had to replace it because this herd of deer that was living in her backyard kept jumping into our backyard, which one, I was worried about them jumping on one of our children, and two, they were bringing ticks. So that's sort of the point when our children switched from playing as much in the backyard to the front yard because of that nuisance. And then while I appreciate Tamara being a good friend to Jess, the visual appeal of the bump out, it will not be visually unappealing from the front of the street, and she's catty corner to us anyways. And I already addressed why we wanted to do the bump out versus in the garage due to concerns about temperature control, mold, and just simple access because we're a multi-sport family. We generally go to one or two, if not more sports a day. And it's much easier to be getting equipment from inside of our house and be having, you know, our 3-year-old going out through a garage door they can't open or to a backyard shed in the middle of winter when we have 3 feet of snow to get sports equipment.
Great, thank you. Mr. Bay, I'd like you to speak to the fact that, about side yard setbacks and how in other neighborhoods they are 3 feet or less in some cases.
Madam Chair, this is Xavier Bay, City Planning. So as you can see on the right up here, this is located within a single-family zoning district. And so typically we're seeing requests for variances within 2-family zoning districts, which are actually 3 feet, as opposed to 1-family districts where it's 10 feet. So that's pretty much the variance asked here today. I mean, yeah, in the past, I believe even last meeting, you've seen someone asking for a variance going into the side yard when they're actually level with the existing foundation of the house. And so for the reason today that we're here, it's because this is a single-family zoning district that requires 10 feet of the side yard as opposed to the 3 feet in a 2-family district. So they're leaving 3 feet and 3 inches. So I mean, it should leave enough room for somebody to maintain the side of both property lines. But that's all I really have to say to this case.
And if you will speak about fencing going on property lines as opposed to being set back?
Fencing, there's, I don't believe, there's not necessarily a requirement for fencing to be set back unless you're on a side street, side yard, or within the front yard. So the fencing is okay to be right on the property line. Typically, you will get written up though if the height of the fence has to be the same height from the main structure or building on the lot. And I'm not aware of the height of the fence, you know, and how that might impact the new build. So I can't really speak to that.
Okay, but on the property line in this situation is acceptable.
Correct.
Okay. All right, Ms. Holzer, question?
Questions for me?
Ms. Roca, question? All right. I'll entertain a motion then, please.
Madam Chair, based on the testimony that we've heard today from all interested parties, I move that we approve calendar number 24-115.
Great. Ms. Holzer?
Board Member Pizarro, second.
Ms. Holzer for the second, if you'll call the vote, Ms. Kukla?
Ms. Holzer?
Yes.
Ms. Roca?
Yes.
Ms. Bay?
Yes.
Calendar number 24-115 is granted. It will be ratified next Monday. We will send the appellant a letter. Please feel free to contact us next Wednesday for further instruction.
Thank you. All right, thank you, everyone. We appreciate all your testimony. We're gonna move on to the next case.
Madam Chair, we were informed that The calendar number is 24118.
Thank you.
132, is that correct? One for just 132.
Yeah.
They are in search.
I'm sorry, what?
They have an issue with scheduling only 5 members of the board meeting.
Okay,
We'd be able to take that case right next. That would be calendar 24-132.
okay. 132 is the only one we're requesting?
I believe so. Yes.
Yes.
I'm sorry. Okay. Do we have any other council people present today?
Madam Chair, I did not see any council people present.
Okay, and I believe you had Mr. Zone, who had been with you as well?
Yes.
Okay, as a courtesy to the former council president, we'll go ahead and move your case forward. If you want to get yourself situated at the table, just pull up a chair. Just pull up a chair.
I just photos of the other things that.
Oh, the site plan should be part of the.
Okay, all right, yeah, it's not gonna be sure.
All right, we're 132 as a courtesy to Mr. Dunn.
Okay.
Whenever you're ready. Yep.
We're good. All right, our next case is calendar number 24-132. This is at 1275 West 69th Street. Joseph Russo, owner, proposes to erect a two-story frame single-family residence with an attached garage in the P1 two-family residential district. The owner appeals for relief from strict application of by ordinances as stated in the agenda and the public record, of which there is one with the note that city planning approval is required for issuance of the permit. With that, I will hand it over to Mr. Rios.
Thank you very much. I'll start with those in the room. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand. Apply what I do. State your name and address. Go ahead, sir.
I do. Joseph Russo, call 48 by 67.
What? I do live in Paul, 7555 Rideau Drive, C210, Concord, Ohio, 44077. Thank you. Is there anyone on the call, on the call for this case?
Good morning, Nate Law, Cleveland City Planning, 601 Lakeside Avenue. I do.
Anyone else? All right, Madam Chair, back to you.
Super, we'll take you through the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. There are no variances on file, and then in our Records Administration Office, we found that in 2012, a permit was issued for residential demolitions. That's all I have.
Okay. Legal standard, please.
Madam Chair, members of the board, the appellant is requesting an area variance from the attached garage requirements in the zoning code. Obtain the area variance, appellants must prove that denying the request will create intractable difficulty not generally shared by the land or buildings in the same district. Will deprive the appellant of substantial property rights, and the granting variance will not be contrary to the purpose and intent of the zoning.
Right, thank you. Elaine, are you gonna be supposed to?
I am. I'll start off.
Okay. Why don't you let everybody know what your role is in the project first?
So I represent Commence Homes. We are going to be the builder of.
We haven't seen you.
It's been quite a long time. Good to be here. We get started.
Go ahead.
Okay, so we are working with Joe and his wife Hannah on a property on West 69th Street. We are proposing to build a front-facing garage with a roof deck and a porch. The garage will be set back 40 feet off the front property line, and the requirement is 46. We're asking for a relief of 6 feet. The reason that we wanted to do a front-facing garage is if we didn't do that, it would be up their entire backyard. And it's important for them to have a backyard, they want to raise a family, and a home, and have some space to do that. They also have a dog, so an area for the dog to move out for the dog.
What kind of dog do you have? It's a bully.
So we kind of worked with them on the design of the home. It's somewhat similar to what we've seen before. We had some modifications to it. The clients have been very active in their neighborhood. They have a 50-person petition in support of this variance request. We also have, I believe that made your packet, we also have a letter from the property owner to the rear that signed in support of this
Does
as
Ms.
well.
Kukla have all this?
I believe she does.
In the petition as well? All right, super.
And then we also spoken with Councilwoman Spencer. She wrote a letter of support in it as well. So we kind of.
So we got that correspondence on file? Yes. Okay, super.
To be any question on the general layout, you can see too, if you go back to the site plan,
You're doing board and batten,
it should be vinyl sided.
vinyl siding. All right. And what's our square footage of the house again?
The house is about 1,800.
1,800.
Your deck would be about 20 by 20 over the garage. And then the front porch is 8 feet.
What's the access from the house onto that roof deck? Hallway or
Yeah,
through a bedroom?
you can see it, you can still like floor plan, you can prove it. But you can see there's a hallway access off the top of the stairs.
Okay. Is there an intention for barbecuing or anything up there?
I would say no, I'm probably far enough, so.
Probably not. Probably getting a lot of trouble.
Probably.
Plus you've got your backyard, right?
I had the back there.
So there you go. So just some luncheon probably, or playtime with kids or something like that.
Someone.
That's good. All right, super. All right, so letter of support from Councilman Spencer. And we had Mr. Zone here. I'm assuming he's not officially with us anymore, but also support. Okay.
You did sign the petition. So he is.
Oh, so he's on the petition.
Yes,
Okay, great. Go ahead.
I was just gonna say also, if you look, we provided a packet for about 60% of the neighborhood has front facing garages, so that was included in there, so it's pretty common in this area.
Right.
That should exist. So you don't think it's out of territory to do that.
Okay, good.
We had a number down too, so you can see how close in proximity the houses are. To the lot.
Excellent. Mr. Bay, do you want to chime in on this?
I'll actually defer to Nathan Ball, neighborhood planner.
Oh, yes, I forgot we had Nathan now with us in person, but with his Nancy headset on. Go ahead, Nathan.
Good morning, Chair and members of the board. So city planning typically doesn't support front-facing garages or front-loaded garages, but I think in this case, they've demonstrated that it's a common condition on West 69th Street shared by the neighbors. And the way that the garage is essentially, I think it's about 40 feet off the property line, which I think is an acceptable condition. We really just typically don't support them because of the possibility of cars being parked on the sidewalk and blocking pedestrian access. But in this case, there seems to be enough room to do this in this way. So we have no problem with the variance.
Great.
It is 40 feet.
Right, I had that in minutes.
Okay.
What garage door did you spec for this?
It's
Solid?
Yeah, it'll be solid.
Solid?
Yeah, it'll be, I don't know if white is usually what we install, but I don't know if they install their.
I was just curious if it was gonna be some translucent kind of material as opposed to solid.
No, it should be solid.
Okay.
Most likely won't be.
All right, we'll go to questions. Ms. Roca?
And just to state for the record, you're not gonna park cars on the sidewalk.
No, it's not.
I think that's always the concern that we have on the board is just pedestrian safety, making sure that people in wheelchairs can get by on the sidewalk and people who walk like me aren't blocked. So provided that you park your cars in your garage. And there's, significant, space here as we testified in like some of the other cases we've seen.
Right.
So, thank you.
This is a generous distance at 40 feet, more than we often see. So, Ms. Holzer?
And I think I heard in my notes that, the goal is to maximize rear yard space. Is there any other hardship that you can attest to if you weren't awarded these?
So if you scroll back to the main pictures of the street, there's like a couple of street pictures that connect to. So if you see like the street's actually pretty narrow compared to most streets. And there's a lot of like as you can see, there's a lot of there's a few tenement buildings there and another one to the north. A lot of renters on the street. So that street gets pretty congested and parked on. So this will provide us with ample room for parking, especially even if we wanted to have guests. I mean, that is a 40-foot driveway, so you could have up to 4 cars, including a car that'll probably be in the garage itself. So it works out pretty well for everybody, including our neighbors, that it frees up more space for them.
What's your driveway width?
It's something 8 feet. It might be, I mean, that could be on there and figure out, you know.
Because that's a double width garage, isn't it?
Yeah, so it's
Probably 12.
Yeah, that's what it looks like actually, if you look at that. Most of them look like that.
Yeah, so it's probably
But I don't see a dimension, like.
So we could get 2 cars abreast and stack them, so you've got really a 4-car capacity.
Yeah.
Just on the drives.
We also want to safety as well.
Yeah, I mean, it would just be a lot safer, even like how Gillian stated that me and my wife back here, we plan on having a family, having a backyard to, for our future children to hang out and play, and be out of the street, stuff like that.
What's the depth of your backyard, you know?
I think it's 63 by 33.
Okay. All right, anything else?
Well, if you have a backyard,
Yeah.
area if you're not.
Exactly, yeah. Do you want to take the motion on this, Ms. Holzer?
Sure thing. Having heard testimony from, the appellant, city planning, recognizing that, there's limited yard space and they're trying to maximize that, I move approval of calendar number 24-2.
Madam Chair, I'll second.
Okay, Ms. Roca? Ms. Cooper, we'll go to the vote.
Ms. Roca?
Yes.
Ms. Holzer?
Yes.
Yes.
Calendar number 24-132 is granted. Will be ratified next Monday. We'll send you a letter, but please feel free to contact us on Wednesday. Have a nice day.
Thank you.
Super, thank you. Good to see you again.
Thank you all so much.
Yeah, I think it's been since pre-COVID.
Yeah,
at least. Oh, it's all,
Yeah.
it's a whole new world. Okay, super. Let's move back to 24-1. Perfect.
All right. Our next case is calendar number 24-116. This is at 5801 Park Avenue, which is located. Joe, I apologize if I covered anyone's name, owner proposes to use as a church in semi-industry. Use as a church in semi-industry district. The owner appeals freely for the church application of the city codified ordinances and statement of the benefit and the public record. One, note that city planning, that I want to refer to Mr. Review.
Haven't seen. Is it just you for this? Okay.
All right, sir, do you swear or affirm that the testimony you are about to give is the whole truth, is nothing but the truth? Please raise your hand, state I do, and state your name and address for the record.
I do. Dennis, the street, DESPIAU, 5801 Park Avenue. No, the church is going to be in the front of the building. I live in the home area. And church is in the front of the building.
So you reside in the rear,
Yes,
church is gonna be in the front,
yes.
okay, all right,
For the record, I'm off the clock, not on the taxpayer.
okay.
Good move.
We appreciate you making it known as that since we saw your shirt, so.
Thank you. Is there anyone on the call for this case? Hear anyone? So back to you, Madam Chair.
Okay, super, we'll take, history of the property.
Thank you, Madam Chair. There's been no change in zoning since 1929. There are no variances on file. We didn't find very much information in our records administration office. We did see that in 1905, there were alterations to the two-story building. The ownership at that time was noted as Belts Brew Company. And then again in 1914, there were alterations and the ownership was noted as Home Brew Company. And then in 1979, a permit was issued to install aluminum siding to a two-family on the address. And that is all that I have, Madam Chair. Thank you.
Super, goes back a bit, doesn't it? All right.
Legal standard. Madam Chair, members of the board, appellant is requesting an area variance from the parking requirements in the zoning code. To obtain the area variance, appellant must prove that denying the request would create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to purpose and intent of the zone.
Great, thank you. All right, Mr. Depew, go ahead and tell us what you want to do.
We'd like to respectfully request a variance on the parking. As you see, on back parking, I spent about $17,000 to, not knowing that I was gonna go through what I'm going now, but when I purchased the building, it was a church already, and it became a ministry, the Lord of God, and I'm the pastor of the church, and when I looked into it for the insurance purpose and stuff, it was never established as a church. It was being a church since the 80s, different owners, they rented out for folks, and I was just doing, improving the area and the parking spaces. I take about 5 or 6 cars in my backyard. My vehicle goes to one of the neighbor driveways, so I got the full backside of the house. And the side streets, they're always empty, and always helping the neighbors because it's a very dedicated area to do it. And people were parking there to do all sorts of transactions. And we took over and opened the church, ministry. So we help the neighbors. They don't mind people from the church parking there instead of illegal transaction. Plus, we're a small Hispanic congregation, and majority of the folks that come to the church, they walk to the church. They're basically the Hispanic area, folks around the area. And it's not really about 10 members tops, and majority of them just walk
Okay,
to the church.
all right. So, so you do your service in Spanish. Most people walk to church, and your congregation size is about 10. Okay,
We also have Mr. Riley, which is the owner of the printing shop across the street. We got a verbal agreement that if we need space, he allows us to use the driveway if we ever need it. Also, the Dara company next door, I also got good communication with them, and but it's on Sundays and they close, they allow us to use the phone. But that's a verbal agreement with them, nothing in writing. Between the space behind my property and the side street. And also, if you see in the map, the Merrill Street, that's a alley. Nobody parks back there. It's walking distance. If I would have to use, hopefully not, but meaning we got plenty of space back there.
Okay.
So.
super. Mr. Bay, if you'll go back to that shot of the existing parking lot.
This one? Here it comes.
Yeah, yeah. Talk to us about how you have it paved and drained.
It's paid by a procurement company, and he drains toward the middle of the driveway, so he goes toward the driveway. It doesn't affect other people's property, or it doesn't cost hazard to.
So there's a storm drain that exists.
Actually, just level and drains naturally towards the street.
Oh, drains, okay, right. And what's your surface? You're finishing, is it concrete?
Concrete, yes.
Okay. And the sheds are yours?
Yes.
Okay,
Those are 80 by 10.
okay,
Like that, just for storage, so
all right, okay,
we don't go inside of it. Beautiful neighborhood.
yeah. Yeah, I can relate. Ms. Holton?
Very many questions. I'm debating whether or not we want something written from the neighbors and they're willing to allow parking on in weekends, but back and forth over whether or not the laws is sufficient.
Ms. Rocca?
Yes, Madam Chair, so just to be clear, the congregants of the church will not be parking in that back parking. There's no technical parking for the church. People can park on the street, they can park at your adjoining neighbor's property with this oral agreement you have. But in general, that back parking lot is for you as a tenant that lives there as well.
We don't rent it out, we just live there until we have any tenants.
Oh, okay, so you
Yes.
just,
I
you're,
just live-
you're.
I occupy the whole property upstairs, I play on for the
Right,
kids.
okay.
Also use it for classes, sometimes for church and stuff. So we have, like, we say about 3 parking available if we need. But like I said, it was about 10 folks that would come to the church and my door gonna walk. Only 2 families that drive in.
Right.
We'll have space on the street.
I think you said you vacate your parking lot and you park off street, so
Yes.
if anyone needs the parking lot.
Correct.
If anyone, I'm assuming if someone's ADA, you probably give them priority if they're handicapped or something.
Yeah, I just wanted to just make sure that, because it's not striped or any of that, so it's not being officially used as a parking lot for the
Right.
church, or else we need to have additional ADA parking spaces
Yeah.
and all that. Okay, so for the record, parking lot is not officially being used for church parking. And then, sir, if you could just describe what difficulty you would face if you didn't grant your variance today.
It's difficult, no, we have to spend a lot of time, money, effort to open the church. It was always a church, but it's been different. I think hardship will be the people that we reach. Like last year, we got the chance to talk to the gentleman. He always go by, we do from time to time a yard sale next to it. And because neighbors allow us to use a little bit of their space, and he said that, you know, hey, let's say goodbye, but I'm going to commit suicide. And I talked to him for a little bit, and he knew that was a pastor of the church. And I, because he was coming on condition, I said, you should live the best days of your life and go to your family and spend it, but don't think that way. And the glory be to God, we were able to talk him out commit suicide. And I think that would be the most difficult hardship for us, not to be able to be there. They can knock on the door, even that we do service on Sundays. They know they can go and knock on the doors. Ladies who walk the streets, for lack of better terms, they have an overdose, they knock on the windows, like call 911, and they able to take. So by not being able to cooperate the church, you know, I still will answer the call, but he hindered the ability of them to see the church open up. It's still the church, because it was closed for a long time of period as well, between, you know, people renting it out, and now it's more constant. They see that we just don't open the church, we live there. It's not something that somebody else, like before, they rent it out and no longer to be seen, because pastor was not there, I live there, I'm in the community. And it will hinder us in that matter of them seeing the door open at least on Sundays and be able to give them guidance, and not just spiritually or programs and such things like that.
Thank you.
Thank you. Mr. Bay, do you have anything you want to add?
Hi, Madam Chair, this is Xavier Bay representing City Planning. We don't have issue with the variances being requested today, especially after hearing that there was an agreement with local owners to help them support parking needs. I'll even mention that there's another church to the north here, or
Right.
I believe that's actually the north. If you go north of the screen, at least, this parking lot here is part of that existing church's parking lot. So I would even recommend communicating with them too, see if they would help support some more overflow parking. But yeah, we don't have any issues with variances today.
Super. Okay, are you comfortable with not making, okay, super. You want to do the, excuse me, take the motion on this?
Having heard testimony from the appellant and city planning, recognizing that there are some verbal agreements in place to address the parking issue. I move approval of calendar number 24-116.
Madam Chair, Board Member Roca, I second.
Thank you. Ms. Kukla? Ms. Roca?
Yes.
Ms. Sullivan?
Yes.
Yes.
Calendar 24-116 is granted. will be ratified next Monday, and we will send you a letter. Please feel free to contact us next Wednesday.
I have a packet that I got that has 2 Narcan doses in it. I should leave it at the office so you can pick it up.
Appreciate it.
Yeah, I'll do that.
Thank you very much.
Sure, nothing I need.
Thank you, board.
Thank you. Thank you. All right, moving on to 24-118.
Our next case is calendar number 24-118. This is at 13509 Tyler Avenue. Michael Fischbach, owner, proposes to erect a 1-story bedroom addition to an existing single-family residence in an A1 one-family residential district. The owner appeals for legal and strict application of the city codified ordinances as stated in the agenda and the public record of ordinance 1. With that, I will hand it over to Ms. Roper review.
Thank you, Ms. Holder. I'm swearing in all who are present for this case. Do you swear or affirm the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, state I do. State your name, spell your name. Go ahead, sir.
I do, Michael Fischbach. CH, 13509 Tyler.
Thank you.
I do. I am here. LEIM.
Is there anyone online for this case?
I am.
Please proceed, ma'am.
My name is,
You
oh,
swear to tell the truth and nothing but the truth. Please state I do. State your name and address.
I do, Tony Jones, TONIJONES, and I'm with Jefferson Puritas Development Corporation, 14703 Puritas, Cleveland, Ohio, 44135.
Thank you. Is there anyone else on call?
I do, Nate Law, Cleveland City Planning, 601 Lakeside Avenue. I do.
Thank you, Mr. Lull. Anybody else? All right, Madam Chair, back to you.
All right, super. We take history of the property.
Madam Chair, there's been no change in zoning since 1929. There are no variances on file. And in our records administration office, we found that in 1951, a permit was issued to erect a single family renting dwelling. In 1953, a permit was issued to erect a private garage. Madam Chair, that's all that we have that is relevant.
Super. All right, Mr. Fischbach. Talk to us about your side yard.
Excuse me, Madam Chair, can we go to
Yes.
legal standard? before we-
Yes, thank you. I was zipping right along there.
Madam Chair, members of the Board of Health is requesting an area variance from the minimum required interior side yard requirements in zoning code. To obtain the area variance upon the design request, create practical difficulty not generally shared by other land or buildings in the same district, and deprive the owner of substantial property rights, and that granting variance will not be contrary to the purpose and intent.
Thank you. I didn't want to feel left out. All right, Mr. Fischbach, go ahead. Yeah, you can take it.
To a tragic event, it's like additional space to live. He's got some grandchildren. Ready to come down. Building not going to preserve where it sits now. Addition here, you have a girl house. It'd be bad. Further and further. They remodel. Exactly, not as wide as the existing house.
So there's gonna be a setback.
A bump in on
A
the
bump
driveway
in.
side with the entrance to the kitchen, which is now the kitchen entrance, will be the additional, the
Okay.
addition entrance. Which then you get into the addition, go into the main house or it's.
Okay. Are you the contractor?
I'm his best friend, I'm retired, and me and him are.
Okay, you're gonna do it together.
Yes.
Good to have best friends like that.
60 years.
You know, I have friends that go back to 3rd grade, so it becomes really valuable, right? Yeah. All right. And what's our square footage on the addition?
It's 25 by 20.
Okay, 500 square feet. You're just gonna tie the roof.
Professional.
Yeah, I see that. Okay. Any correspondence from the council person? Liz?
No, we don't have any.
Okay, super.
You have a letter from the neighbor on the, you know, the short side.
Okay, did you submit it to Ms.
I-
Cooper?
I said, yeah, I don't know if
Yeah.
you got it.
Okay,
And Mr. Bay has it.
all right, super. All right, excellent. Okay, all right. Ms. Jones from, you want to go ahead and make a statement?
Hi, Jefferson Puritas doesn't see any reason to, deny his application. We spoke to him and we do see that there is an undue hardship by him needing to raise his grandchildren. We also spoke with the councilman and he has no issues with the new addition.
Okay, good. You had council input from them then. Great. Okay, Mr. Lull, to you.
Good morning. Yes, we agree with the CDC and the councilman. It seems like all the houses in this district, this limited one-family district, are pretty close to the property line, so they likely don't conform as it is right now.
Right.
And this addition is still going to be 10 to 12 feet away from the property, the building on the next door parcel. So we don't have any problem with it.
Okay, great. Ms. Holzer, questions?
No questions from me.
Ms. Roca?
Oh, I guess I should ask, so can you state in the record what you're not ready?
Well, I won't have room for the grandkids, so I either have to sell, which I can't afford to do that right. So that's the whole problem. There's no room for it. The older they get, the smaller the house gets.
How old are they now?
8, 9, and 13.
Mr. Bay, you have anything else?
No, Madam Chair, good night.
All right. Want to take the motion on this one? Sure.
Having heard testimony from the appellant present today, as well as the CDC, and having heard via the CDC that the councilman is, doesn't see any issues with it, as with city planning, I move approval of calendar number 24-11.
Great.
Board Member Roca, I second.
Thank you, Ms. Roca. Ms. Cooper, we'll call the vote.
Ms. Roca? Yes.
Ms. Holzer?
Yes.
Ms. Bay?
Yes.
Calendar number 24-118 is granted. It'll be ratified next Monday. We'll send you a letter, but please feel free to contact us next Wednesday for further instruction.
Yes.
What will be a different phone?
So in
You
our,
guys send the records down there, so. I can-
you'll have to carry them down there. So somebody will have to come in and pick them up from our office.
On
We can do
Wednesday.
that on Wednesday, yes.
Next Wednesday?
No,
Next Wednesday.
So they'll meet again on Monday and
Okay,
ratify.
just want to get this up before it's
Got it.
notified.
Yeah, yeah.
Not as
Well-
young as I used to be.
We'll ratify it next Monday, and then it'll go into the system, so you can pick it up on Wednesday of next week.
Thanks.
Okay, and you can move on.
Thank you.
And,
Great day.
I'm sorry that you're in this situation, but, good luck to you, and, thank you for being able to step in.
Good day.
You as well.
Great day.
Thank you. All right. Thanks for spending the morning with us. We'll have you move to the table. Thanks. All right, our last case, 24-087.
Our last case is calendar number 24-087. This is at 1305 West 91st Street. I apologize if I butchered your last. How do you pronounce it? Anorzi.
Yeah.
Okay. Leo Anorzi, owner, proposes to establish use as limited lodging, parenthetically commonly known as Airbnb, for more than 91 days per calendar year in a two-family residential district. The owner appeals for relief from strict application of the Cleveland Codified ordinances as stated in the agenda and the public record, of which there is one. Just to note that this case was postponed from July 8th, 2024. And I'll hand it over to Ms. Roca for you.
Thank you, Ms. Holzer. I'm swearing in all who are present for this case. I'll start with you here in the room. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please reply with I do, raise your hand, and state your name and address.
I do. Leo Anorzi. 1305 West 91st First Street, Cleveland, Ohio, 44102.
Thank you.
Just spell your last name for the court reporter.
ANNORC.
Super.
Is there anyone on the call for this case?
Nate Law, Cleveland City Planning, 601 Lakeside. I do.
Thank you, Mr. Lowe. Anybody else? Hearing none, no one else, I'll turn it back over to you, Madam Chair.
Great, thank you. Excuse me. Ms. Kupa, did we do history of the property when we heard this originally?
No, we did.
Okay, let's go ahead.
Madam Chair, there's been no change in the zoning since 1929. There are no variances on file, and we only found in our records administration office that in 1974, a permit was issued to demolish a private garage, and that there were general maintenance repairs done at that time as well.
Thank you. Legal standard, please.
Madam Chair, members of the Board of Health is requesting an area variance from the limited lodging requirements of the zoning code. Retain the area variance for the denying request to create practical difficulty not generally shared by other land or buildings in the same district. Would probably be opponent of substantial property rights, and that granting variance will not be contrary to the purpose and intent of the zone.
Great, thank you. All right, sir. Go ahead and tell us what you want to do as it pertains to the variance that you're seeking.
Okay, yeah, and as a matter of fact, it was my neighbor that told me to put this on. I wanted to sell this house twice, but, you know, again, we didn't make up, because they thought maybe I'm a foreigner, and I like foreigner. If I get contract with change, I mean, that's what. Yes, you know, the first student that I didn't, the other one I had. You know, they went back, after I signed it, they went back and changed the whole contract. So if you go and see it, I really see that pull out from the deal, from the road. So the lawyer wrote me a letter to sue me, and I told him what happened, and they backed up. Say, you know, my agent was trying to change the contract. Even though he was, I think I signed it, before he was telling me verbally what to do. I said, no, that's not what I was to put in writing. And my wife saw it, she saw everything. So after I tried to show it twice, it was giving me a lot of credit. Oh, okay, and here's what I told you, she said, hey, go ahead and, you know, put in some Airbnb. After all this, the guy just by. Airbnb. He was telling me what that guy was doing. He said, people was asking me, why is that house? You know, it's a nice house. Why is it not used? I mean, look, this lightning is 24 hours a day. So they keep on inquiring. Someone was calling and said, hey, go do that. I said, okay, let me try. So when I went to Airbnb, I looked at everything, my husband requirements. And I spent more than almost $15,000 for new bands, everything nice inside. Okay, I said, let me see if I will try Airbnb. Airbnb said I was getting security requirements in order to apply. It's okay. So I came here, I thought maybe it was, I see yes, it is. So I heard around March, I think it was March 25th, they didn't apply, and they gave me the plan, you know, decided to make the plan, and again, I submitted everything. I said everything's going to be very good. But they never responded to me until April 30th. I came in and said, why no response? They thought there was something, I think that glitch. Okay. It's actually go somewhere and look at my pay. And I paid all the fines and everything. Now they say it's millionaire. I said, but what is that now? I mean, the requirements, any house can go to Airbnb. And Airbnb is gonna look at the house. You're gonna put a picture of your on file, and they're gonna look at it inside what's in there. Everything that brand new beds, everything super clean in that house. So I don't want to say, but what's the issue? I don't understand what the issue. I mean, I don't understand why the city did that, or is it up to code or what? So, to be honest, I don't understand here, somebody's gonna do that. 30 days, again, that is, this is my, it should be next time. I don't understand why it's that.
Okay. Mr. Bid, do you want to answer this question or you want to defer to Ms. Leonard to go over the Airbnb requirements and restrictions?
Thank you, Madam Chair. Yeah, I'd actually defer to Ms. Leonard to go over the specifications of the Airbnb regulations.
Okay, Ms. Leonard is online. Ms. Leonard, I'm gonna have you address the appellant for us. And if you can explain to him, the restrictions and, on the Airbnbs, on the limited lodging.
Yeah, good morning, Shannon Leonard, Chief Zoning Administrator, so the limited lodging.
You're a little garbled, Ms. Leonard, you're a little garbled.
Hear me?
We're having connection issues today.
I can hear you perfectly. You just can't hear me.
We can't hear you. Are you on site? Can you just come down the hall?
Can you hear me now?
What?
Can you hear me now?
Not really.
No, not really.
I'll walk down the hall. Give me 2 minutes.
Not sure what she said.
She said she'll walk down.
Okay, great.
Madam Chair,
I know last week we were having hotspot issues.
if I could take this moment, the reason this was postponed last time was because the councilwoman asked for a postponement so that she could meet with the appellant. At the time, she said she received the notice. She's requesting a postponement for a number of reasons. Sometimes there are nuisance with these Airbnbs. She would need time to request calls for service for the property and then examine whether any nuisance conditions exist. She also asked for the applicant's contact information so that she could receive direct information from them. And so, Madam Chair, we did postpone that, and the appellant was sent an email from our office, and we copied Councilwoman to connect them together. Now, today we have, or sorry, this was last week, we received an email from the Councilwoman stating that she was unable to get in contact with the applicant.
All right. So you have not met with the councilwoman at this point?
I think it was postponed, though. I mean, I was ready, that's later, and I got an information that it was not ready. So I thought I think that was a good call.
Okay, we have Nate with us, right? All right. Nate, do you want to give us your statement at this point? We're waiting for Shannon.
Sure. Good morning, Chair. Happy to. I didn't catch much of the conversation in the room due to the microphone issues, but I do believe that this is the first case we've had under the new legislation to allow Airbnbs in the city on a restricted basis, as long as they register and no more than 15% of the street is dedicated to Airbnbs. In the past, a consideration that we've had is whether the applicant for the Airbnb is a homeowner and whether they're local. I think those are still really important things in any context of approving an Airbnb. So with that in mind, I think it's possible to say that under the new legislation, since there's no other Airbnbs in the street, as long as they were to register with the city, they'd be allowed to. But I think this application was sent in before any legislation took effect. So that's why we're reviewing it under the previous laws of no more than 90 days, or else it would be kicked over to BZA essentially. So I don't know that we really have a position on this one. It seems like those two sort of factors about the homeowner, if the applicant is a homeowner there and lives there, and if there's a 15% or more on the street already, which there isn't, would be important factors for the board.
Okay.
We're having microphone difficulties, so it's, yeah,
Yeah.
Sure.
Explain to him what's going on.
I'm the zoning administrator. So 588, ordinance 588, 2024 has been introduced. I don't think it's been passed fully by council. This application came in before that ordinance, obviously it doesn't pass council.
Right.
So the only thing that we can judge it under is the limit of lodging. And the only enforcement is the beyond 90 days. So it'll be short-term rentals being used, more than 91 days out of the calendar year needs to be for. So he's not the first that's come before you in the last couple of months since that ordinance was introduced. And since the new law has come down around limited housing. And so he is one of the first to come before you, but he won't be the last.
Right.
In terms of, the new ordinance allows short-term rentals in any residential district, starting from single family going up. But then there is a density buffer, so when you're more than 15% of a block or building on a specific block between two intersecting streets. And so it's really a first come, first served kind of thing, but it does require a license. And so that's the biggest part of this new ordinance is that a license is going to be required, an annual license. And that annual license has everything to do with, one, making sure the city can account for where all of these are, making sure that they don't have any calls of service from 911, making sure that it's really not interfering with the character of the residential nature of the neighborhood. And that's the whole point of it, is for the city to really be able to get a hold of these in some of the more, touristy areas of the city. And so this is near Edgewater, and so it does have several that we know of just by knowing, basically complaint driven or otherwise, just people reporting it. But otherwise, there's no actual determination. And so what this will require is if we do pass the variance, he will be grandfathered in, as will any others that have been passed previously. But he will have to get an annual license when that's ordinance fully passed.
Okay.
Well, all short-term.
So I just want to make sure I'm clear, based on this new ordinance, if this board grants Airbnb variances, the Airbnb property can be used as Airbnb by any owner in the future as well. It doesn't, so it's not specific to this owner, it's specific to the property. So if he sells his property, the new owner, and they want to use it as Airbnb, they don't have to come back before us again.
So this is, so here let's back up. So let's call it a short-term rental because Airbnb is a brand name.
Sure,
And so
short-term
I don't want to just generalize humans over lines. And so short-term rental, the variance would run in perpetuity with the property, but it's not a guarantee that it could continue in the short-term rental. The new owner would have to apply for a new license. And it has to be a local owner. So you have to have local, if it's not the local owner, they have to have local representation. There's a handful of items to make sure that somebody can respond to the address 24/7, essentially, for any kind of guest. And there's a laundry list of items. I think maybe I read the ordinance for you. That's been, proposed. But you also need to tax it. So if somebody buys it or builds a new home, they won't have tax payments in the way. There's a lot of things that have been checked out, but it's not a guarantee, even though the variance runs in perpetuity with the property, it's not a guarantee that they would get the license to actually operate. You have to have that license.
So if the new, say, a person has an Airbnb or a short-term rental variance, and they sell their property, and then the new licensee wants to use that property as a short-term rental, they just apply to building and housing for a new license, but they do not have to come to BZA again.
So the only variance that you would be granting today is to use it for short-term rental for longer than 91 days in a calendar year. In this case, this person, if you were to grant variance today, would be grandfathered in because they're first come, first served. We're not aware of any more on the street currently, but they would have to apply to assessments and licensing for that annual license. And that annual license can be denied on a variety of those factors that we mentioned.
Okay.
So they could come back before you at some point, like that annual license was denied.
I see, but there's not a automatic, it's an automatic right essentially that the new owner of the property would apply for a license, and it's assuming they met all the requirements that you list the requirements, they could get a license without coming back.
Yeah, but they could do that anyways. So let's say the ordinance passed and they're the first owner that comes through with a request of a license. All we're doing from a zoning perspective is saying there is no time limit on the new, right? So all we would be looking at is there any more licensed short-term rentals on this street?
Yeah.
And if not, then you would grant the license, assuming they meet all the other requirements of all the service, maintenance, taxes, all those local, regulations.
Okay, all right, so I guess my question to the appellant is, you live in Cleveland, and you stated your address for the records, your local ownership. Sir, what will you do to prevent, we have seen, in the city, issues with short-term rentals having large groups of people, and causing nuisances and disturbances to their neighbors, large parties, large parties, really, and you have a 4-bedroom unit, would be a larger short-term rental. What will you be doing? Are you gonna have a property management company? Are you gonna be managing it? How are you gonna prevent large nuisance parties from happening at your restaurant? What will you do about it if something like that happens?
You know, all of the attractions, you're gonna pick exactly the condition for rent. And in some of these countries, the area you are like, so camera, you're gonna tell them. So that we did see a number of people, I mean, it's easier to tell them that, you know, it's a camera. You tell them, this is, it's 4 bedrooms, you only want 4 people. When you see that, okay, maybe it's gonna, find it, it's, they are paying $100. So all this information, Airbnb, if I work at Siemens and with an Airbnb, all we must say is Siemens, no policing name. Well, if you say you're gonna only no more. Okay. And by having the camera in that house, you're gonna see the camera in there. They gotta be doing that. Don't see anything with the camera in there, know exactly how many people. I mean, we see that number, okay? That evidence, everything is gonna be, so you will never comply with that rate. So everything you're saying now, everything you address, always issue. In some instances, some people compensate if there's a game now, right? People will come in there, it's not bad. Guess what? That was not the idea. You said you're gonna come in there by yourself. Bring every people in there, without sort of but because of that, again, it's a clause in that. I don't know, they made you should say, but you're saying, I say that you should the relation that I said, 2 weeks, but then that's legal. And if I say 2 years, that's the condition that you know, maybe not well, that provided that we thought of this. If all Airbnbs, you put down cameras to cost. So to protect you and to protect you, the customers. I mean, you still have this camera in the okay? I mean, it's good for you to stay there because you cannot just tomorrow without enjoying that camera. So that's everybody. And they also, in the case of this problem, maybe you the outside, not inside. You cannot tell exactly who can get all the time. So what you're saying is correct. So missing and rest. So you have to find out all these issues you always have to never if you also protect Airbnb, it's a cost. Yeah, because Airbnb, the real beneficial things to us to protect Airbnb is huge. So what you're saying is that you
Thank you. And then, so you're gonna be managing the property yourself, not
Yes.
gonna have.
Look, as a matter of fact, I will manage that. I will manage that.
How closely do you live in this vicinity? Do you reside close to this house?
Look, I have two houses. My property is in this house.
Your apartment is in this house?
No, my property, I reside in this house, okay? They come, okay, you must be doing this, more like friends.
Right.
And in Airbnb, in fact, if they come in that house, if they're cooking, you won't come in there and start 15 minutes, just like someone rents in a hotel. I mean, you cannot live in a room in there, it's somebody else.
So you reside in this house?
Yes, yes.
And your plan is when you rent it out, you are just gonna go off premises
Yes. Look,
to someplace else?
yeah, you know, the issue is, okay? I reside in this house. Residing in this house means I have my property there, maybe 2,000 back to Google. Okay, I use this as a point of contact. Okay, for 5 years I have this house. I've been trying to sell it. That's the issue.
Yeah.
5 years. So if you look at me, I'm getting access to the area. It's not. You don't get it. I'm bringing it to you. It's not like everything is shut up.
No, we just wanna know how it, I mean, I think it gives us more peace of mind to know that you actually reside in the house.
Yes,
And you're just gonna make other arrangements.
yes,
You run it down.
yes. Yes.
Anything else?
Yes.
Okay, Ms. Holster?
I think I will take this question then, just generally, what hardship would you experience if you were not awarded the variance? So if you're not able to move forward.
Okay, now, I spent almost $15,000 for the new fence, everything. Look, I didn't think it's even, I wanted to put, when I came to that office, I told them to see, let me show you everything, but he said, no. Okay, I went to American office. I don't know, maybe I should have brought that to you. I don't know what I did there. Okay, if anybody wants to come and stay in that house, come in. I didn't get you, but thank God, Airbnb, they want to see this fucking job, what to try to rent out.
Right.
So it's not like I'm just giving it time, but back in there, everything.
So you would lose your investment
Yes, I do.
if, as a hardship,
Yes.
if we didn't grant the
Yes.
variance.
Yes.
You would still reside there, but you also didn't have success in trying to sell it.
Okay, and if I sell it, I have to sell everything though. And again,
Correct.
yeah, and if I sell that house, now you bought something, trying to sell it, you didn't make money at all. You're just taking money in which you're gonna pay tax. You know, if I sell that building, I spend more than around $15,000. The money I already put in there, okay, because I stood for almost 3 years and now you taxes on that. I've not done tax benefit. Because they're gonna say, you cannot take it back for 3 years.
Right.
So, okay, you see how I'm losing money?
Right.
Yeah.
I think that answers Ms. Holzer's question.
Yeah.
Madam Chair, could I read the letter into the record from the council person?
Yes, please do.
She sent this on August 8th. Says that she's writing to express opposition to the requested variance for this address. Although she appreciates the applicant seeking a variance rather than legally operating an Airbnb, she did not hear back from the applicant as requested by the board. In her experience, there are too many risks to the community associated with potential short-term rental nuisance. So she opts to proceed with caution. More information would have been needed about the nature of this business model. And it also would have been appropriate for Mr. Nord to contact, sorry if I butchered that, to contact neighbors on West 91st Street to explain his operations. Finally, she mentions that the council will hear legislation in September that will change the local laws in regards to short-term rental. Once that legislation is approved, the appellant will have the opportunity to apply for short-term rental license under the new process.
Okay.
And that's all.
But what is,
Thank you.
what is essentially the difference? I mean, the essence that it's easier under the new process, it just adds, he's gonna need to have it. So like, let's say the variances come today, You still are gonna need to apply for that license once they get up and running.
Right, so it's literally gonna.
Yeah.
Yes, because he wouldn't have to come with PCA.
Right.
So unless he was the third person to apply for a license.
Right, so if his variance is awarded today, he still, once the legislation passes in September, he still has to get a license under that legislation anyway.
Right.
Yes, and
Okay.
Yeah.
Okay, can we make sure he has a contact person to help him through the licensing process?
yeah, as soon as we leave out of here, I can give him my card and give him Xavier's.
Okay.
Okay, let me see, I think you see the address. Look at this, I can get March 25th.
Okay.
Right.
I wasn't contacted until I came into the contact me. They said, I said, it was all right, no, okay. He said, you're gonna contact me. They didn't contact me. Okay, so I came in.
So, right, so here's what we're gonna do, okay? What's going on, as Ms. Leonard explained, is there's legislation that's pending through city council. That's gonna change the rules on how limited lodging are gonna be able to operate within the whole city. You're kind of coming in early before that's getting passed. So if you came in after the legislation were to be passed, you wouldn't have to come before us.
They passed the variance, will grandfather in, so I can see the lights. So what they're suggesting is that come September, we call Mr. Xavier, he will guide you in the right direction of how and where to go in the right. But it's gonna get to you.
Yeah, I understand that, she was saying that, not contacted, she was on the way.
Right, so here's what we're gonna do right now. We've heard all the testimony. We've heard from Ms. Leonard. We've heard from the city planner for your area. We've read the councilwoman's letter into the record. But based on the testimony we've heard, we're gonna go ahead and make a vote on the variance now. But we're giving you Mr. Bay's card there, the business card. Guard that with your life, because you're gonna wanna get a hold of him to go through your licensing process.
It's gonna be up to you to call.
Okay, my wife actually said, why did this delay? I don't know what answer for it, I said,
No, it's not your fault, it's because of the legislation. Yeah,
Yeah.
you have an absolutely really good excuse, and she can't be mad at you.
So I have to wait till.
Right,
No,
we're gonna do our vote right now, and then we'll give him instruction. Okay? All right, motion?
Yes, Madam Chair, based on the testimony that we've heard today from all interested parties, I move that we approve calendar number 24-087.
Second,
Board proposals are, I second.
thank you. Call the vote.
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Biggs.
Yes.
Calendar number 24-087 is granted. This will be ratified next Monday. We will send the appellant a letter. You can also contact us next Wednesday for further instruction regarding the variance.
Okay. Is that something, can he, if we have him come back next Wednesday to pick up his ratification?
As soon as he comes back, once that ratification goes through, it will get routed back over to building and housing. They'll have to pay the plant examiner fee. If the plant is building and housing, we do a code review, make sure that this house is set up for more transient guests, if you will, rather than a permanent living space.
Yeah.
Making sure there's proper ingress and egress, and then as soon as that goes through, he'll be granted a permit to operate, and he can go ahead and start renting out once he gets that permit, and then, but when October comes, he needs to make it his priority to reach out to Xavier, and Xavier will have instructions on how he needs to go about getting the assessment.
Okay, so 1st of October?
I mean, I would recommend that.
Okay. So, sir, what you wanna do, make a note. Okay, on that business card, you need a pen?
Okay.
You got it? All right,
Yes, I got a pen.
okay.
Yeah.
So October 1st, you're gonna call Mr. Bay. Because you've got to get your license, and he's gonna help you get your license.
Direct you the way to go.
Direct him in the way to go. And next, we'll have it ready for him to pick up next Wednesday, Liz?
Yes,
Okay,
not the license, the application.
right, the application. Yeah. Next Wednesday, you're gonna come to our office and see Ms. Kukla.
Okay.
Okay,
Next one. Every 7 days from.
today's the 12th, so that'll make it the 19th,
19th. Okay.
all right? No, that's not right, 21st.
Okay.
So on the 21st, you're gonna come and see Ms. Kukla.
Ms. Copeland?
Her, right there.
Oh.
Right there, right there. But not during her lunch hour.
No problem. Thank you.
And you're gonna pick up the ratified variance.
Okay.
And then you're gonna start moving it through the process that it has to go through building and housing.
Mm-hmm.
And there'll be a fee.
Okay.
What else does he need? That's it. What's the fee? No? All right. So be prepared to pay a fee,
No, I'm.
all right?
Yes.
And that'll get through the process and then you'll start rolling along. Okay?
Thanks.
Super. All right, you're on your way. Okay. All right. Tell your wife you're not in trouble.
Yes, I'm gonna tell her this.
Okay?
Yeah. Okay, thank you very much.
All right, have a good day.
Listen to you.
All right, old business, 1 through 8.
I'm only gonna say no objection to number 8, since I was not here.
You were not? That's right. Okay.
Although you're listed,
Is that one?
Is that,
One for.
no, she's just listed for.
I thought we were talking about 8, are we not talking about 8?
We're talking about 8. She said she was gonna say okay to 8,
Oh, okay.
but not the rest, because she
Oh,
wasn't here.
okay, I see.
So we'll do number 8. Number 8 without objection.
No objection.
No objection.
Okay. And then you and I will do 1 through 7.
No objection.
All right. Awesome. And then we have 16. What's going on with 16? Are we good to go on that?
We are. You received the documentation about the filing.
Yes.
We're going to dismiss this case. We never received the updated drawings.
Okay.
And so we will officially dismiss it. But the applicant undertakes and will fine.
Right.
But, you know, officially did not have his variance, therefore he can't get a permit. I believe it was a country that had already been arranged, so I guess at this point, building a house and get siding again.
Okay.
We'll communicate with them.
Okay. You want to go through the affirmation then?
It's a simple one. This is their first affirmation request. As with many of these, they're still working on the architectural drawings, full specs.
Right. Sure.
And it's an addition.
Okay. Without objection, board?
No objection. No objection.
Super. Don't start. Please don't start. All right. We are adjourned. 19. Anybody absent?
Not absent, but I'm gonna have to excuse myself, all the pieces, there's the agenda.
Uh-huh.